Okay, so this is a joint work in collaboration with Francesco Olivieri at Griffith University. Now, well, this work essentially, it's an extension of what Alice just presented, and essentially it's in the area of computational law. Computational law is the foundation of what we call the ruler's code, and in our view, computational law is just the use of logic, formal model in particular, to first determine what normative positions or obligations, prohibitions, and permissions are in force in a particular situation. And then after we have what are the requirements, legal requirements in force, we can determine whether they have been violated or complied with. And all of these, it can be done by a machine processable, in a machine processable way. Okay, so that it was my introduction, and then we can go to the actual problem we wanted to address in this presentation and with this paper. Typically, the complexity of legal document, it measures in terms of the length of the document, and it has been argued that the use of references, internal references, or references to other part of document, other part in the same document, or to other documents, it's one way to reduce the complexity of the document because they reduce the length of the document. However, there are several problems. First, when you have references, you introduce a level of opacity because, well, you can just see a reference to a section, but you don't know what the section is about, or you don't know what is the content of that particular section. And on the other side, if we wanted to encode normative documents, normative systems, taking a ruler's code approach, we have a problem if we use references because they reduce the opportunities to encode or to translate using the isomorphism, the legal isomorphism. The legal isomorphism is that the idea that when you convert a legal document, you want to convert just a part, and when you convert a part and you look at the corresponding encoding, then essentially there are no external dependencies. So if you change text, part of the text in the textual provision, you only have to change the corresponding encoding. But if we have the references and the references must be embedded, then essentially we might lose this correspondence. So, and then essentially here I want to just to give an example of what we mean by legal references. So here I have a few examples. So the important part here is that you can see that there are some references to other clauses. So here, here we have, well, in section 982, we have, well, that's something, it's applicable in section, according to sections 991H, and we have no idea what are those conditions. Similarly, when we look in sections 9.8.2 of the Telecommunications Consumer Protections Code, we can see that there is a reference to something has to comply, somebody has to comply with what's specified in sections 9.9, and then also we will have that there will be exceptions to 9.5, 9.6, 9.7. And when I look here, I have no idea whatsoever on what is the content in 9.9 and 9.5, 9.6, and 9.7. Now, I also have a more interesting case. So when you look here, section 26.105 of the Income Tax Assessment Act, well, as you can see, there are many references. Here we have both external references to a different act. Then we have a bunch of reference where possibly those sections applies in this particular section here. And finally, we have something about failure to comply with another section. So as you can see, references are quite common in legal documents. And if we want to encode those documents in a computer, in a machine executable way, we are able to solve them. Otherwise, we cannot do the encoding and we cannot reason about that. So what is the solutions to do it? Well, the solution is then every time we have a reference, we are going to replace it with its logical representation. So, for example, if we have that section 1 can be encoded if A, B, and C, then D, and we have a section 2 saying, well, if section 1 applies, then E, then what we can do, we can represent section 2 if F, B, and C. So we take essentially the logical representation of section 1, and we replace for section 1, and then we include in the other sections. Now, what we have to understand that when we do this manual process, in many cases, we have to do some logical inferences. So here, well, you can see that, well, I have in parentheses, which might be optional, I don't know, I have and this. So do I have to consider D because it's part of the meaning that section 1 applies or not? And in other cases, I have to do more complex reasoning tasks. Well, our solution is, well, we don't want to use, we don't want to replace with a logical structure, but we want to just represent them. So what we do, we start with defeasible Deontic logic, and we extend with reference literals. So we will have expression in the language, such as apply sections, complied sections, violated sections, and then the logic is extended with conditions that allows us to determine when apply sections, comply sections, violated sections hold in a particular situation. And then essentially this is what we're going to do in the rest of the presentation. And then if we take this approach here, what we can do, we can just represent, if we take the previous example, section 2, and then we can write in this way. So apply sections 1, then E. And then essentially, we leave the resolution of this condition, of this norm, to the internals, to the logic itself, and then essentially we don't have to perform as encoder the evaluation manually, but then the evaluations will be done automatically by the system. So here it's just my used cars salesman pitch for defeasible Deontic logic. So it's a rule-based non-monotonic formalism. It is efficient, indeed. It has linear complexity. It has unnatural directly skeptic semantics. So it means we don't have to compute all possible extensions and take the intersections. We can do the computations directly. And related to this, it has a natural ability to model exceptions in a natural way, in an efficient way. Also, when we consider the extensions with the Deontic component, we are able to speak about the Deontic aspects, obligations, prohibitions, and permissions, and violations. But at the same time, we can explain the reasoning mechanism of the logic using an argumentation Lacan structures. But at the same time, it has a constructive proof theory. This means that it's fully explainable, and every time I have a conclusion, I can just provide you the full trace of the derivation. I can provide all the facts, all the rules, all the norms that apply, that are used to determine a particular conclusion. We show that other formalism often used in AI and law are just variant of the logic and with some differences. And we have used in different field, and we have a couple of optimized implementation. Alice in the previous presentation discussed Turnip, one of the most modern implementations, though in some way still partial. And also, as Alice mentioned in the presentation, we've used defeasible Deontic logic in several exercises, in several massive scale encodings of acts and regulations. Also, it is extensible, which is a part of what I'm going to do today, and essentially the extension is how to do with the legal references. And also, well, as we know, in most cases, Deontic representation have suffers from paradoxes, but defeasible Deontic logic, for several reasons, something very simple, is not affected by them. So defeasible Deontic logic is a combination of defeasible logic and efficient non-monotonic logic for the representation of the exceptions, plus a Deontic logic of violation for the representation of the Deontic concept of obligation, prohibitions, and in particular violation. Defeasible theory is the way we structure our knowledge, and essentially it corresponds to a set of facts which will correspond to the facts of a particular case, a set of rules, and the rules will correspond to the encoding of a piece of legislation, and finally a superiority relation. The superiority relation is an internal mechanism to describe the strength, the relative strength of rules in case the rules are for opposite conclusions and they both fire at the same time. So we can determine that one rule overrules or overrides one of the other rules, and then we can discard one of them. It's just what the language we use, so we just have plain literals or atoms in Alice's terminology in the previous presentation. Also, we have deontic operator, so we can say that something is obligatory, or the negation, which corresponds to prohibition, that something is permitted, and so on. But furthermore, we have a compensatory operator represented in this way, and the meaning is that, well, P1 it's obligatory, but if it's violated, then the violation makes P2 obligatory, and doing P2 compensate for the violations, and then we can apply for all of them. Furthermore, as I said before, we extended with apply, complied, and violated, where R is just a rule label. Well, so I spoke about rules, and then essentially we have two types of rules, if-then constructions. So here we have what are called constitutive rules. Constitutive rules are rules used to provide definition of terms. And the idea is that, well, when A1 to AN also, when the condition to apply the rule hold, then we produce the effect. For a constitutive rule, we have that we provided the definition of a term, while for a prescriptive rule, we have a similar structure. We use the obligation, and the meaning of prescriptive rule is to generate obligations or prohibitions or permissions. So if A1 to AN are the case, so if they are true or they're all in a particular case, we are allowed to conclude that C1 is obligatory, plus since we might have a longer expression with the compensations, we can apply those operators and so on. Now, here in this case, we can say that if A1 to AN all, then we have that C1 is obligatory. And if it is violated, so if we have the negation of C1, not C1, we have that C2 it's obligatory and it compensates for the violation of C1, etc. And we can repeat for all of them. Okay, so this is a very basic definition of the defeasible logic, of the Deontic defeasible logic. And now we can consider what does it mean to reason in the logic itself. Well, if we want to prove a conclusion, then what we have to do is to give an argument for the conclusions we want to prove. But then we have to consider all possible counter arguments against it. And finally, we have to rebut. And we have two ways to rebut a counter argument. Either we can defeat the counter argument by a stronger one, or we can undercut, so we can show that some of the premises do not hold. So the basic construction is that, well, we can say that an argument is a basic fact, or there is a triggered rule for A, and either all the rules for the opposite are discarded, are not applicable or not triggered, and every triggered rule for not A, it's weaker than a triggered rule for A. So the key point to determine what does it mean for a rule to be triggered. So if we have a rule, and it could be either a constitutive or a prescriptive rule, well, the definition of trigger is very, very simple. We need to have that all the elements in the if part in the antecedent A1 to AN are provable, and that is the basic condition. Now we can start to speak and say, okay, now what does it mean for a rule to be applicable? Well, here we have an assumption that essentially a section corresponds to a rule. It's a big assumption, but it's in this stage because when you really model and you encode real life acts in documents, we have that sections will be encoded by many, many rules, but we can easily handle and extend to handle those cases. So we can concentrate just to a single rule. Now, here we have two possible interpretations for the meaning of applicable. The first one is that we can say that, well, the rule is applicable. And then in our terms, it also means that, well, the reference limitable applicable are, it's provable. So we can say that it's true. And then the first option is that we just consider the antecedent of the rule, so A1 to AN, so only the condition of applicability. However, if we consider again the first example I gave you, so from the Telecommunications Consumer Protections Code, in that case, a rule is applicable if, well, first of all, the condition, the trigger of the rule applies, so all of them are provable, but also we have that the conclusion, so the effect of the rule, also in this situation, or it's provable. And also we can express that using R. Now, here we have a problem because when we take this definition, we have to consider that might be some rules for the negation. And essentially, we have to incorporate in the proof conditions, in the derivation conditions, how to consider that there might be some possible counter arguments for the conclusion and so on. And so essentially, we have to consider those two options to specify when a rule is provable, and in the paper we did it. Now, what about when we move to defining the conditions when a rule is complied with or violated? Well, first of all, the rules must be a prescriptive rule, and then we can say that a rule A1, AN, prescriptive rule C, it's complied with, and then in the simple case, it's simple. We have that the condition to trigger the rule, the condition of applicability also are provable, and then since we want to, it's complied, the meaning of the rule is to produce the obligation of C, and then to comply, we have that also C should be provable. And then when we want to consider it violated, then essentially we have this first condition is the same. We have that we need to be able to prove the obligation of the effect of the conclusion, and also that the opposite of the content of the obligation of the conclusion is provable. Okay, so it seems quite simple. However, what about if we consider this, let's say, this fragment of a license here? So here we have that in some cases, a particular section can include what are the legal requirements, so a prohibition to do something, and then at the same time, they might specify possible way to recover from the violation. So what does it mean to violate or comply with those complex expressions? So when you read this text, it says essentially, well, you have the prohibitions to publish the result of evaluations, but if you publish when you were not allowed, then you have to withdraw within 24 hours. When do we comply? Of course, if we don't publish, we comply. But what about if we publish and we remove it? Do we comply or not? And similar, we can ask the same question for violation. Well, based on these discussions, then essentially we can extend the definitions. And then when instead of a single element in the conclusion of a prescriptive rule, we have a chain considering possible obligation and the possible compensations, then essentially we could have possible meanings. And essentially we have, of course, the rule must be triggered, and then at least the first element must be provable, and additional conditions. In the paper, we really give the proper conditions to specify different alternatives and the different degree of complied with. And similarly, we can do for the notion of provable. Of course, we have to have the opposite, but something more. Okay, so that it was just the idea. So in the paper, essentially, what we did, we studied and defined different types of legal references and how to represent them in the logic. We provide sound and complete algorithm to compute them, and we study the complexity. The key aspect, and well, I don't know whether this is a positive or a negative result, we proved that when we extend the logic with the legal references as presented in this paper, the complexity is still feasible, it's still polynomial, it's quadratic, and then we have an increase because the complexity of the logic when we don't have the references, it's linear. So on one side, we maintain feasible, but we increase, so it's much more. Now, we don't really have any practical experiment to see whether the overhead, the fourth power, it's really a problem or not. I expect probably it might not a serious problem, but it's something we need to study more in the future. So let me go to some possible ideas for future works. Well, we have that references. One of the other possible uses of references is to represent the norm changes. So very often when you want to modify some norms, you specify a reference and how to modify in the particular reference. And in the past, we use nested rules to model norm changes. So what we want to do, we want to extend the framework to model norm changes. And in a couple of months ago, we had another paper where we extended the feasible logic and the computational model of the feasible logic to handle nested rules. So what we want to do is to integrate the algorithms and the computational model presented here with the model for nested norms. Then I said, well, that in real life norms, what you have to do is to consider how to handle set of rules instead of single rules, because, well, often sections reference will be modeled as sections will be represented by a set of rules instead of single rule. And at the same time, we want to have an optimized implementation. Unfortunately, for some, well, unfortunate reasons that, well, the Data 61 terminated research in computational law, it's unlikely that we're going to do in the near future. So, well, thank you very much for your attention, and I'm open for questions. Thank you very much again.
Thank you very much. It was very interesting. We have a question for you from Marcelo Lopes. He's asking, is the model proposed by you efficient for all types of legal references, or is it more efficient for some types and less efficient for others?
Well, based on the results, it doesn't matter the type of references you have. If you have the reference that they speak about apply, complied, and violated, we have that it's still efficient. It's in the fourth power in the size of the theory. I don't expect to be a real problem from practical point of view, because if you really wanted to model the corresponding text and the references by other techniques, you still have to blow up the underlying theory and the underlying set of rules. So my educated guess at this moment, since we haven't done any experiment of this, is that, well, there will not be real differences, and then it is efficient to model all types of legal references.
Okay, thank you very much. Do you like to say a few words before we finish the panel?
No, that's it. Thank you.
Mr. Guido, we have two questions for you. The first one is from Hugo Lopes. Thank you very much. We have been working on the problem of references in laws, which in a way relates to the notion of compositionality in both logical specifications and business processes. As you mentioned, sometimes one could substitute a reference by its cousin rules, but in other cases, it seems that some references block executions until reduced. Do you have any thoughts of whether the order of application might need to change?
So strictly speaking, the order of application, it's not affected if you have references. However, some computations might be delayed, and actually this is showed by the complexity, because when we have references, we move from linear complexity to the fourth power. So essentially, we have to run more cycles to see exactly when the references are solved or not. Whether this is a practical problem or not, I'm not really sure, as I mentioned already in my presentation, simply because, well, if you include the logical representation of the references instead of the references, you still have to compute them first, and essentially you are going to blow up your initial data structure. So I don't expect to be a real problem, and technically speaking, it doesn't affect the computation, even if there is some overhead.
Okay. The second question is from Hilary Smith. For the task of formalizing legal norms, is there any difference in terms of complexity between internal references and external references?
For our method, no, there are no differences. There will be just plain references. There might be some minor concern. One of the concern will be, well, we don't really know what the external references are. It might be that they might refer to full sections or full parts, or to a complete entire regulation. So from the representation point of view, it will be just one line. From the actual computations might be much worse. When we deal with internal references, we have a much more clear idea about what they are, or at least it's easier because we can check the same document. Now, the problem will be much, much worse if we have to replace them, because in case of the external document, in the worst case, we have to encode the entire external document inside. And for the internal, we still have the problem of the internal references. But for us, it will be, from the representation point of view, it will be just one symbol, one element. From the computation point of view, it really depends on what is encoded in the reference itself.